Hi, and thank you for joining me here on YouTube. My name is Will Hannosh. I'm an attorney here in San Diego, California. My office is right here in the heart of the Mission Valley area. I've been practicing since 2007, so 16 years. And my two main areas of practice are family law and elder abuse. Within the family law context, I do divorces, legal separation annulments, custody visitation matters, support hearings. I also do adoptions and restraining orders. For the elder abuse side, I represent victims of financial or physical elder abuse. So please feel free to call me if you have any case matter that is within those two arenas or contexts. The topic that I want to talk about today is one that I don't think you're going to hear a lot of attorneys talking about, and that's how can you save on attorney fees and costs. And before starting my practice here in Mission Valley, I've worked for previous law firms, and part of working for a small or medium-sized law firm is that sometimes it's easy to get lost in the shuffle. A client may end up speaking to an office assistant, and then the paralegal, and then the client may decide they want to speak with the attorney directly. And there's a lot of back and forth. There's a lot of give and take when it comes to phone calls, voicemail messages from those phone calls, emails, replying to emails. Sometimes the attorney responds to the paralegal, and the attorney will tell the paralegal, please make sure you email or call that client to double check to make sure what they meant about X, Y, and Z. And so there's a lot that can happen that can cause a client to get lost in the shuffle. And you don't have to have a very large firm for this to happen. It could be a small firm of 4 or 5 people, and a client can still feel like they're getting lost in the shuffle. So that's the reason why I made this video today. I want to explain to you, the client, how you can take steps to save on attorney fees and costs. And I've seen these mistakes made by clients over and over and over in my 16-year practice, especially with larger firms. So I want to pass this advice on to you so you can take some steps to, if at all possible, to lower your fees, to at least to whatever extent is within your personal control. Because I think it's important, because people don't normally, the average person on the street doesn't normally have to hire an attorney, but when they do, it is expensive. I'm not going to lie, and every attorney you speak with would agree. Tip number 1, if you cannot come up with a large retainer deposit, whatever that amount may be, to hire an attorney to handle your whole case, you should still check to see if you can find an attorney who will work on a limited scope. Now, this is obviously a need for those who cannot come up with a large retainer payment to hire that attorney to, say, carry the football, or to take the whole case, carry the football from one end zone to the other, so to speak, to use football talk. If you can't hire an attorney to take on your case because it's going to be too much for you to pay, and I understand that, here at a law office of William Hannosh, we do offer services on a limited scope. I'll say this, and I know a lot of law firms in town will cringe, they'll kind of shy away from doing this, but I've acted as ghost attorney for many, many clients in my career. What does a ghost attorney mean? It just means that you come into my office, I'm giving you advisory help, I'm giving you strategies, perhaps maybe coming up with arguments or points that you can solidify for yourself in order to get yourself ready for that hearing or day in trial. I'm not going to your hearing, and I'm not going to your trial. You're just coming in, meeting with me. You pay me on a per hour arrangement. So my hourly rate is $300 an hour, and I've had many clients come in, pay that hourly rate if they need to use 2, 3, 4 hours, what have you. then I give my clients the freedom to do that. I've acted as ghost attorney. What that means is nobody knows I'm behind the scenes. I've acted as ghost attorney for many clients in the past, and I have no problem doing that. Other law firms might. And I've also acted as attorney for people who are hiring me for a limited scope. What that means is they don't want me to represent them during the whole case. They perhaps want me to just work on discovery, or they want me to just prepare them for their settlement conference or mediation. I do that as well. I'm happy to work on a limited scope. If your personal budget only allows you to do that, I will work with you. And so that's important. The other tip I would ask, one thing I would state though, however, is that the State Bar of California does have strict rules. This is important to point out, that if you are going to hire an attorney to represent you, I, as an attorney, must have a signed retainer agreement with you, the client, if you are going to pay me $1,000 or more in attorney fees. In that regard, I would need to have a signed retainer agreement with you, the client, and that's in the State Bar ethics rules. That's important to note. Tip number 2, I cannot tell you how many times I've represented clients who'd have questions for me over the life of a case, who would repeat the same questions or ask the same questions multiple times, yet not write down the answer for themselves. And I know this sounds very commonsensical and maybe basic, but tip number 2 is get a notepad and get a pen or pencil, or if you need to write down the notes on your notes application in your iPhone, do that. But write down what your attorney is saying. There is a reason why people are having to pay attorneys a heftier fee for their services, because attorney's advice is very specialized. It is based on experience. It's based on skills. It's based on an understanding of the judicial system and legalese that the average client may not know or understand. So if you're asking an attorney to explain complicated or complex procedure to you, you're not really familiar with the legalese anyway, it's a great idea to just get a notepad, and just write the notes on that notepad. I can't tell you how many times I've had clients come to me and repeat the same questions. And I think we don't want to lose sight of the fact that attorneys in general, attorneys all across America, I can say that, are basically selling their expertise in time. They're selling their expertise in time units. So if you're paying for an attorney's time, it is well worth your while to just write that advice on a notepad. If it means having a little bit longer of a meeting with an attorney just to do that, just so that you can internalize the information and understand it for yourself, then I strongly, strongly encourage that. It's better than repeating your question to an attorney and then having to pay for more time that you could have saved for yourself. It's just good stewardship, in my opinion. I think tip number 3 would be, after you sign that retainer agreement with the attorney, you definitely need to know what the strength of your case is based on the facts and realities of the case. You want to know what kind of witness you'll make, what other witnesses and evidence there are in your case, if there are witnesses and evidence. Please take this advice to heart, because it can only help you, the client. If your attorney or the attorney's paralegal is calling you, asking for documents, asking for items of evidence, asking for statements or what have you, you want to get that information to that attorney or paralegal sooner than later. Ideally, what should happen is this. If you tell your attorney, hey, give me a list or give me an itemization of everything you need from me, can you just put it in one list for me? The attorney or his paralegal will do that. I do that all the time. I'm happy to do that for you. We send you that list. You know exactly what it is you need to get to us. And ideally, if you look at that list and just go, A, B, C, D, and knock that bullet checklist down as you go, that's really the best way to get information or evidence to your attorney. It's much, much better, I promise you, from experience, and having seen clients' invoices in the past for previous firms that I've worked at. It's much better than having a constant, perpetual give and take by phone and email, and it's just better if you could sit down or gather all the evidence and documents your attorney wants from you in one sitting and get it to him. That's always going to be ideal and much better. Each time an attorney or paralegal has to call you or email you or send you a reminder email to ask for evidence or forms or documents, remember, your attorney's retainer agreement, and I can speak for other law firms, I'm speaking for myself, and I'm also speaking for other firms, your retainer agreement says that the attorney and paralegal can charge and will charge for that time. So it's better to just kind of knock it all out in one sitting if you can. Tip number 3, there's something called formal discovery. I will not go into a long, complicated definition of what discovery means because I don't want to waste your time, but discovery among attorneys and judges simply means this: you have information and I need it. That's what discovery means. So every litigant is allowed, has rights to pursue discovery, basically send formal requests for information or statements or documents. Discovery is a right you have within your case. Is it meant for every case? Not really. Can it get expensive if you start pursuing formal discovery in your case? Absolutely. This is one area that I take very seriously, and the reason I take it seriously is that discovery is it remains the client's choice. If the client tells me, you're my client, you walk in, you hire me, and you say, Will, I need you to conduct formal discovery on that side. Let's say we're going through a divorce, and you say, I don't know how much he's really making. I think he's making about $80,000, but when you add in the commissions and bonuses and what have you, he's really making about $115,000 a year. That might require discovery. Discovery is something that I don't pursue until you tell me to pursue it. The reason why I don't pursue it until you tell me to pursue it is because I know that it can get awfully expensive. It's going to increase your fees with me. And I also know that the party on the other side will use discovery simply as a tit for tat or method of showing vengeance. So if we serve them formal discovery, they also have the right to serve formal discovery on us. They usually do. And there you have, all of a sudden, an expensive discovery war. This is why I always leave it to the client to decide whether they want to pursue discovery or not. In many cases, they're compelled to, but I still give that decision to the client because I believe as a practitioner, and I don't know if other attorneys agree with me here, but as a practitioner, I agree that clients should decide whether they want to pursue discovery. The same goes with motions. The same goes with requests to be filed with the court. I, as a practitioner, don't file motions and requests with the court unless I've discussed it with my client, they're on board with it, and they've also sent me a writing, either an email or something in writing asking me to pursue a motion or a request. These are some really important things I would just go over as far as what are some basic commonsensical ways where you might be able to save yourself just a few bucks as you pursue your case and as you have an attorney represent you. Remember, if you can't pay that larger retainer deposit, there's always something called hiring an attorney on a limited scope basis, and the San Diego Superior Court system has a form, California has a form, called Notice of Limited Scope Representation. I'm happy to do that. I've done it for many clients, and if you just want to get advice, you just want to get some help on filling out forms, you want to get an attorney's help, but you don't want the world to know that you even have an attorney, I'm happy to act as a ghost attorney. Have done it many times, and I've had many clients come out of their trials with successful outcomes. I encourage that too if you're looking to save some fees. If you like this video, please give me a like. And if you want to contact me to set up a consult, my phone and email are down there. I'd love to meet with you, love to talk with you about your case, and I really look forward to us meeting. Have a great day, and thanks for seeing me here on YouTube. Bye.